question is to the Attorney-General, Senator Brandis. I refer to the government's proposed changes to the EPBC Act, which remove the rights of third parties to challenge environmental approval decisions in the courts. Is Prime Ministerial confidant and commentator Alan Jones correct in his assessment that, and I quote, "the latest move by the Abbott government puts at risk not just our environment but our very democracy"?
Order. The Attorney-General, Senator Brandis.
Well, Senator Singh, no. Mr Jones, if he said that, I haven't seen his remarks, but if he said that, that is not correct at all. Let me, if I may, Senator Singh, explain to you what the government intends to do. Section 487 of the EPBC Act creates an exception to the ordinary law. The ordinary common law rule is that a person is entitled to commence proceedings, including proceedings for administrative review of a decision-maker's decision, if that person is affected by the decision. That is the law. That has been the law since time immemorial. Anyone who is affected has a right of standing before a court or an administrative review tribunal. Section 487 of the EPBC Act created an exception to that traditional common law principle by giving standing to apply for review of administrative decisions made under that particular act to anybody who was an Australian citizen or a person ordinarily resident in Australia who had at any time within the previous 2 years had any involvement whatsoever in any activity relating to conservation or research into conservation. Now, Senator Singh, unfortunately, that provision, inserted, I might say, by the Howard government in order to give genuine environmentalists an additional forensic benefit in disputed environmental decision, in the review of disputed environmental decisions, has been availed of in recent years by vigilante litigants who are quite shameless in their declaration that they intend to use that enhanced statutory standing for the purpose of economic destruction.
Thank you, Minister. The time for answering the question has expired. Senator Singh, a supplementary question.
Thank you, Mr President. I find it very surprising that the Attorney is not aware of the comments of Alan Jones, which have been plastered on TV ads on every television screen. Supplementary. Is the National Farmers Federation right to be concerned that the standing of farmers and their representative bodies could be affected by the government's attack on the EPBC Act?
Attorney-General.
I've seen Mr Brett Fedlay's comments, Senator Singh, and those others of the National Farmers Federation. Any farmer, any landholder, any businessman who is affected by any environmental decision will have the standing to challenge that decision, to seek administrative review of that decision. They do not depend upon Section 487 of the EPBC Act for that standing. They do not. It's very simple, Senator Singh. If they are affected, then as a matter of ordinary common law principles, they have a standing in the court and they have a right to challenge that decision, I should say. If they are not affected, then they rely on Section 487. But Section 487 is not the basis on which a person affected by a decision can challenge it. They can challenge it under the ordinary law.
Thank you, Minister. Senator Singh, final supplementary question.
Thank you. Sorry?
Order. Just to the question, Senator Singh. Ignore the interjection, Senator Singh.
What's Andrew Bolt said? Can the minister confirm that in the 15 years since John Howard introduced these environmental approval laws, only 6 out of 5,500 approvals have been successfully challenged by third parties? Is it any surprise that even Alan Jones thinks that this bad policy is an abuse of power?
Minister.
Well, Senator Singh, what we are concerned about is responding to the threats, and you were in the chamber, Senator Singh, in the last sitting fortnight when I read from the declaration that a group of radical environmentalists and environmental groups had published to declare that they would use legal devices, including the expanded right of challenge under Section 487 of the EPBC Act, for the explicit purpose of closing down the Australian coal industry. Now, Senator Singh, in my state of Queensland, the Carmichael mine is one of the biggest projects that has ever been proposed, and the people of central Queensland in particular are appalled at the thought that the jobs that would be brought to central Queensland could be lost as a result of opportunistic litigation by people with no recognised legal interest in the matter whatsoever, but merely a political point to make to misuse the courts for their purpose.
Minister. The time for answering the question has expired.